Hi, my name is Amelia Glimpf, a labor relations specialist with the Field Services and Education Department at AFGE. In this video training, we will discuss management's rights. Most union officials dread hearing the agency claim a proposal cannot be bargained because of management's rights. Usually, management invokes management's rights as a way to limit the involvement of the union in important workplace issues. But even if they do, and even if they are right in identifying a subject as a management right, and don't assume they always are, the agency still has bargaining obligations. As we've discussed in the training video titled Mandatory, Permissive, and Prohibited Subjects of Bargaining, there are certain subjects we can't bargain the substance of because they are management's rights. You may recall that under 5 U.S.C. 7106B, management rights that cannot be negotiated away include determining the budget, organization, number of employees, internal security, and actions which may be necessary to carry out the agency mission during emergencies. But let's look closer at how the agency is still required to bargain. The first step when management claims a subject is prohibited because it is a management right is to ask them to explain why. Ask them to show exactly what about the proposal is a management right. Show you where it's covered under the statute and show you any case law evidence that similar proposals have been found to be outside the scope of bargaining in the past. If they can't show you, they may be wrong. Be prepared to research to confirm or refute their claims. First, the management rights clause in the labor relations statute starts with a notice that in exercising these rights, that exercise is subject to bargaining. 5 U.S.C. 7106A states, subject to subsection B of this section, so we jump to subsection B, which reads, nothing in this section shall preclude any agency and any labor organization from negotiating. The management right clause in the statute is predicated by the union's right to bargain. Remember that the feared management right clause is conditioned on an obligation to bargain if the union so demands. The purpose of the management rights clause in this statute is to define the scope of bargaining for these rights, not to prevent bargaining over them. This is codified in subsection B2, procedures which management officials of the agency will observe in exercising any authority under this section, or B3, appropriate arrangements for employees adversely affected by this exercise of any authority under this section by such management officials. So when management exercises a management right, the union has the right to bargain, but the scope of bargaining is limited to appropriate arrangements and procedures. This is frequently called impact and implementation, or I&I bargaining. We will discuss that in greater depth in another video. When management declares a management right, it serves to remind us that the first step in bargaining is to define the scope of the bargaining that applies. If the agency was wrong and the issue is not actually a management right and is not prohibited, we can bargain the substance, what is in their proposal or change itself. If it is a management right, we may bargain over the impact and implementation of that right, the more limited scope of bargaining of appropriate arrangements and procedures. Often, unions are confronted with a declaration of non-negotiability by management because the matter is an exercise of a management right. Take as an example, management rights to hire employees. Remember, even if the substance of a proposal, the right to hire, is a management right and non-negotiable, union proposals concerning appropriate arrangements and procedures are within the scope of bargaining and therefore negotiable. Sometimes a management change contains matters which are both the exercise of a management right and those that are not. In these instances, both scopes of bargaining may occur during negotiations. We will bargain substance where we can, and procedures and appropriate arrangements where we can't bargain substance. This is why you see in CBAs and notices to the agencies in the union's demand to bargain the statement to the fullest extent of the law. Remember, examine all claims that any portion of the issue is closed off as a management right and research it to confirm it. Preserve the right to bargain over the substance of an issue where you can, and assert the right to engage in impact and implementation when you cannot. Just because the agency claims the issue is non-negotiable because it is a management right does not mean they don't have the obligation to bargain. Always remember to assert your right to bargain and that it can be the difference that makes us big enough to win.